Hello friends, myself Mohit and I am going to dictate you Steno legal matter. Please subscribe my channel and press the bell icon for more dictations. So be ready for the dictation. 5, 4, 3, 2, 1, start.
In common cause, a registered society, this court, while dealing with the issue held in case of trials before sessions court, the trials shall be treated to have commenced when charges are framed under section 228 of the Code of Criminal Procedure 1973 in the concerned cases. Stop. In cases of trials of warrant cases by magistrates, if the cases are instituted upon police reports, the trials shall be treated to have commenced when charges are framed under section 240 of the Code of Criminal Procedure 1973, while in trials of warrant cases by magistrates when cases are instituted otherwise than on police report, such trials shall be treated to have commenced when charges are framed against the concerned accused under section 246 of the Code of Criminal Procedure 1973. Stop. Section 2G CRPC and the case law referred to above therefore clearly envisage inquiry before the actual commencement of the trial and is an act conducted under CRPC by the magistrate or the court. Stop. The word inquiry is therefore not any inquiry relating to the investigation of the case by the investigating agency, but is an inquiry after the case is brought to the notice of the court on the filing of the charge sheet. Stop. The court can thereafter proceed to make inquiries, and it is for this reason that an inquiry has been given to mean something other than the actual trial. Stop. In the court, while considering the provision of the old code, the law commission's recommendation and the provisions in the CRPC held that section 319 CRPC is an improved provision upon the earlier one. Stop. It has removed the difficulty of taking cognizance, as cognizance against the added person would be deemed to have been taken as already against the other co-accused. Stop. Therefore, on magistrate committing the case under section 209 CRPC to the Court of Sessions, the bar of section 193 CRPC gets lifted, thereby investing the Court of Sessions complete and unfettered jurisdiction of the court of original jurisdiction to take cognizance of the offence, which would include the summoning of the person or persons whose complicity in the commission of the crime can prima facie be gathered from the material available on record, though who is not an accused before the court. Stop. Accordingly, we hold that the court can exercise the power under section 319 CRPC only after the trial proceeds and commences with the recording of the evidence, and also in exceptional circumstances as explained herein above. Stop. There is yet another set of provisions which form part of inquiry relevant for the purposes of section 319 CRPC, that is, provisions of section 200 CRPC applicable in the case of complaint cases. Stop. As has been discussed herein, evidence means evidence adduced before the court. Stop. Complaint cases is a distinct category of criminal trial where some sort of evidence in the strict legal sense of Section 3 of the Evidence Act 1872, hereinafter referred to as the Evidence Acts, comes before the court stop. There does not seem to be any restriction in the provisions of Section 319 CRPC so as to preclude such evidence as coming before the court in complaint cases even before charges have been framed or the process has been issued. Stop. But at the stage as there is no accused before the court, such evidence can be used only to corroborate the evidence recorded during the trial for the purpose of Section 319 CRPC if so required. Stop.